Call the meeting to order. First item of business is request for deferral of application or any request for withdrawal of an application. Adoption of the minutes.
I move.
Moved by Bill Unger, second by John Andrews.
Moved by Bill Unger, seconded by John Andrews, resolved that the minutes of the meeting held on September 27th, 2023 be adopted. Ian Fleck,
Yes.
John Andrews,
Yes.
Tom Marks,
Yes.
Bill Unger,
Yes.
Dave Jenkins,
Yes.
John Selden.
Yes.
6-0, the motion is carried.
The next item is any business arising out of the minutes? None. Any disclosure of pecuniary interest or general nature thereof? Any correspondence items for information?
None, Mr. Chair.
Business arising correspondence, there'll be none. New business? Well, then we're into consent applications. Application number E69-23. Take notice that an application has been made by Caitlin Crowley for consent pursuant to section 53 of the Planning Act 1990 as amended to sever lands municipally known as 6501 Springfield Road. The applicant proposes to sever a parcel with a frontage of 121 feet, a depth of 90.44 meters, 296 feet, and an area of 3,327.5 meters, 0.8 acres to create a new residential parcel. The applicant is retaining a lot with an area of 7,705.6 meters squared, 1.9 acres, proposed to remain in residential use. Do we have any applicants or agents wishing to speak to this part? Please introduce yourself.
Through the chair, this is Caitlin Crowley, planner with Zelenka Priamo. I am the agent for this application. I just wanted to make note that I have read the staff report and agree with staff's recommendation as well as the conditions as proposed. I will be available to answer any questions the committee may have. Thank you.
Thank you very much. And I'll ask Paul to give us a report.
Thank you, Mr. Chair, through you to the committee. So this application is for a new residential lot to be created within an existing settlement area. The County of Elgin official plan designation on the subject land is Tier 3 settlement area. It's designated as a hamlet in the local official plan, and it is presently zoned hamlet residential. As it is within a settlement area, section 1.1.3 of the provincial policy statement applies to the severance, which encourages a settlement areas be based on densities and mix of land uses and includes residential uses and infill and intensification. With respect of the County of Elgin official plan, as I mentioned, it is designated as a settlement area currently, and that permits new lot creation. Staff have reviewed this application against the general consent criteria of the County of Elgin official plan, and we have noted no deficiencies. With respect to the Township of Malahide official plan and zoning bylaw, their staff have reviewed the application against both of those and found no issues. Township Council have recommended that the county approve the application with conditions. The county conditions being requested on this application are: number one, digital copy of the draft and final deposited reference plan be provided to the county. Number two, solicitor undertaking to provide a copy of the registered deed for the severed parcel once completed be provided to the county. Number three, municipal addressing be provided to Elgin County by the municipality to the satisfaction of the county. Number four, direct connection to a legal outlet for the severed lot is required if an existing connection is unavailable to the satisfaction of the county engineer. All costs to be borne by the owner. Discharge of water to the county road allowance is prohibited Number 5, that if necessary, an entrance permit be obtained from Elgin County for a new entrance to the severed and or retained parcels. All costs associated with this shall be borne by the owner. Conditions from the Township of Malahide on this application are: number 1, that the applicant initiate and assume, if required, a revised assessment schedule in accordance with the Drainage Act as amended, with a deposit to be paid in full to the township prior to the condition being deemed fulfilled. If the deposit does not cover the costs of the revised assessment schedule, the applicant will be billed for any additional costs incurred. Number 2, that the applicant initiate and assume, if required, all engineering and construction costs associated with the construction of a new municipal drain or the relocation of a municipal drain to be commenced in accordance with the Drainage Act. All costs to be paid in full to the township prior to the condition being deemed fulfilled. If a lot grading plan is required as a condition of severance, it should be done in conjunction with the new municipal drain or relocation of the municipal drain. Number 3, that all entrance permits are acquired from the appropriate road authority as per our entrance control policy. Number 4, that the applicant be required to retain the services of a professional designer and have an engineered lot grading development and ditch grading plan prepared in accordance with good engineering practices that are suitable to the township prior to the condition being deemed fulfilled. The applicant will be required to comply with bylaw 05-59 for the dumping of fill, removal of topsoil, and alteration of grades when a building permit or other site works are completed. The need for a certified grading plan and or municipal drain connection will be determined at that time. Number 5, that all outstanding work orders or bylaw enforcement issues be resolved to the satisfaction of the chief building official prior to the condition being deemed fulfilled. Number 6, that the applicant initiate and assume all planning costs associated with the required minor variances required in accordance with the Planning Act, with such costs to be paid in full to the township, and that the required process be successfully completed prior to this condition being deemed fulfilled. Number 7, that the necessary deeds, transfers, and charges for certificates and or instruments necessary for registration be completed prior to certification, of all of which are to be fully executed. Number 8, that all municipal property taxes, municipal fees, and charges be paid to the municipality prior to the stamping of the deeds. Number 9, that the electronic version of the reference plan be submitted to the satisfaction of the municipality. Number 10, that the applicant is responsible to apply and pay fees to the township with respect to specific numbers and signs for severed and retained portions of property prior to the condition being deemed fulfilled. And finally, that in accordance with the Planning Act as amended, the owner pay a cash in lieu of parkland fee in the amount of 5% of the value of the land. The owner shall provide at their sole cost an appraisal of value of the land from a certified Canadian residential appraiser to the satisfaction of the municipality. Thank you, Mr. Chair.
Thank you, Paul. Any questions from any of the members of the committee? John?
Through you, Mr. Chair, to Paul, is there any concern about the retained lot shape because of the, well, just the way it's just the way it's left, that flag shape? Is that a problem at all? I think it was addressed, but I just wanted to ask you about it.
Through you, Mr. Chair, the municipality flagged no issues from the county's perspective, since that would be a zoning concern. We just defer to the municipality on that.
Thank you.
Thank you, Paul. Any other comments or questions?
Moved by John Andrews, seconded by Tom Marks, resolved that severance application E6923 be approved with conditions. John Zeldin,
Yes.
John Andrews,
Yes.
Tom Marks,
Yes.
Bill Unger,
Yes.
Dave Jenkins,
Yes.
Ian Fleck,
Yes.
6-0, the motion is carried.
The decision rendered today for this application will be circulated within 15 days. There's a 20-day appeal period from the giving of the notice of decision, during which the applicant, the minister, a specified person, or any public body may appeal the decision or any condition imposed. If no appeal is received within 20 days of the giving of notice, the provisional consent becomes final. The applicant has 2 years to meet the conditions imposed and submit the necessary documents for certification, or the consent will lapse and a new application will be required. Please leave the identification signs in place until the appeal period ends, after which they can be removed. If you would like to be notified of today's decision, please request a copy by emailing landdivision@elgin.ca. A copy of the comment package is also available upon request and includes all correspondence received. Thank you. Applicants or agents or interested parties who wish to speak to this application, please introduce yourself to the committee.
Good morning, Mr. Chair and LDC members. My name is Simona Rasanu. I'm a planner with Strick Baldwin Limones and the agent for this application. I would like to make a short presentation. Should I do that now or should I wait for the staff report to be summarized?
I'll do it after the staff report.
Okay, thank you.
I'll now call on Paul to give the report from the municipality and the county.
Thank you, Mr. Chair. So through you to the committee, this application is to create a new residential parcel. The applicant has identified in the planning report a mix of agricultural and residential uses, but staff do take issue with that designation given the size of the property. The subject lands are located within the agricultural area in the County of Elgin official plan. It is also designated agricultural in Malahide's official plan, and is currently zoned small lot agricultural in the zoning bylaw. As LDC members are no doubt aware, the provincial policy statement strictly regulates lot creation within the prime agricultural area. The specific section of the PPS that deals with lot creation in prime ag areas is 2.3.4. Lot creation in prime agricultural areas is discouraged and may only be permitted under a few circumstances, and those are agricultural uses, provided that the lots are of a size appropriate for the type of agricultural uses common in the area and sufficiently large to maintain flexibility for future changes in the type or size of agricultural operations, agricultural related uses, those uses that benefit directly from being related in close proximity to existing agricultural uses, things like grain elevators, feed shops, uses such as of that nature. And of course, surplus farm dwelling severances, which the Land Division Committee deals with on a very regular basis. This would not be considered a resident surplus to a farming operation. The applicant has identified that much in their application, nor would it be an agricultural related use. Where staff take issue with this application on the grounds of the provincial policy statement is identifying agricultural uses as a justification for this lot creation. As you can see, the proposed lot area is less than an acre for the severed lots. The retained land is also roughly the same size, just under 1 acre. In terms of agricultural uses in the area in Elgin County in general, there is no agricultural lot in active agricultural operation in Elgin County that is of that size. And I would be very shocked if a farmer would be willing to purchase a 1 acre parcel for an agricultural operation. Section 2.3.4.3 of the provincial policy statement specifically states that the creation of new residential lots in prime agricultural areas shall not be permitted, except in accordance with the policies relating to surplus farm dwelling severance, which again, this is not. If you look at the agricultural uses in the immediate area, none of the lots that aren't primarily residential or the result of surplus farm creation are anywhere near 1 acre in size. The Elgin County official plan also, of course, largely parrots the provincial policy statement requirements towards lot creation in the ag areas. Because the provincial policy statement doesn't offer a specific size for agricultural lot creation, the County of Elgin official plan does have a specific size that we're looking for, and that would be that each agricultural parcel is 40 hectares in area for both the severed and retained lots, unless there's criteria in the OP allowing a smaller size. In terms of the Township of Malahide's official plan and zoning bylaw, staff at the township have reviewed this application, and it did go to council earlier this week, I believe. Township of Malahide's council recommended that the Land Division Committee deny the application on the basis that it does not conform to their official plan and zoning bylaw. With respect to the zoning bylaw, the planning justification report submitted states that agricultural uses are permitted in the A4 zone. This is a small lot agricultural zone. However, in the Township of Malahide zoning matrix for the A zones, for all the agriculturals, A1 through 4, A1 to 3 permits agricultural uses, which are what you would zone a standard farm. A4 uses permit restricted agricultural uses. That's more in line with something like hobby farming. And it's really a replacement for a previous zone that they had. And it's just more or less to permit existing residential uses that are already in the agricultural area to continue and allow hobby farms on farms that are hobby farms that are already being used for that purpose. But in terms of farm operations in this typical sense that we deal with here at LDC, if you were doing an agricultural lot split, which we have done in Malahide in the past, those lots are A1 or A2 or A3 zoned. So as I mentioned, the Township of Malahide passed resolution October 19th, 2023, recommended that the Land Division Committee not approve this application. County staff are in agreement with the township's recommendation and Malahide's council. And as such, we are recommending that because this application is inconsistent with the provincial policy statement, does not conform policies, that this application be denied. Thank you, Mr. Chair.
Thank you, Paul. I'll now ask for the comments from the planner for the applicant.
Yes, good morning again. So my name is Simona Rasanu and I'm the agent for this application. So I reviewed the staff reports provided by the planning consultant on behalf of the Township of Malahide and Paul Clark on behalf of Elgin County, and he just summarized his report for you. I was not invited to attend the Malahide council meeting since it was not considered a public meeting. So Malahide Council made its refusal recommendation without hearing from the applicant or any other party besides Malahide staff. Having said that, I would like to take this opportunity to summarize why you should approve the consent application. The subject property is designated agricultural area in the county official plan, agriculture in the Malahide official plan, and A4 or small lot agricultural in the Malahide zoning bylaw. The existing land use designations and zone are not proposed to change, and the severance does not trigger any zoning deficiencies. In other words, the proposed severed and retained lots would comply with all applicable zoning standards, including for lot area and lot frontage. Although the existing property is not farmed, the A4 zone does allow for limited agricultural uses. The lots created by the proposed severance would retain this zone, and the resulting parcels could be used for both residential and small-scale agricultural uses in compliance with the zoning bylaw. To address staff comments, although it is true that lots zoned A4 are not typical of the farm lots in the surrounding area, their minority status is not a sufficient reason to refuse the consent application. The A4 zone, which provides for agricultural lots in the rural area with a minimum lot area of 2,000 square meters or 0.5 acres that are primarily residential in nature, exists in the zoning bylaw. And similarly, zone lots are found within 1 kilometer of the subject property. And examples include 52516 Carlton Line and 6716 Sawmill Road. I hope you will take the existing facts into consideration and approve the required, the proposed consent application. Thank you for listening, and I'm happy to answer any questions.
Thank you. Is there any, the members have any comments?
Through you, Mr. Chair, to the planner. Essentially, is what you're saying is it's an A4 now, it's going to be an A4 afterwards, and the size is not particularly relevant. The fact that you've got 2 lots now under the same designation instead of 1, if you're granted this severance?
Yes, the zone would remain the same, and the areas and frontages would comply with the existing zoning bylaw. And each lot would be almost 4,000 square meters.
Yeah.
I'm sorry, I didn't understand the last comment.
You were breaking up, sorry.
Yeah. So what I said is that.
Mr. Chair,
Sorry.
could Paul comment on
Okay, go ahead.
what? May I ask?
Yes.
Paul, go ahead.
I'm not
You got
hearing
a
any.
comment to make?
Are you asking me something? I'm not hearing anything.
We lost.
I'm having trouble hearing voices. Assuming somebody is talking.
Are you there?
Yes, I'm here, sir. Can you hear me? Elgin County, can you hear me?
Can't hear you. You're breaking up.
Well,
Hello, Elgin County here.
yes, hi.
Hi.
I can hear you. Can you hear me?
Yes, I
now.
can.
Go ahead.
So was I just asked the question? I think I answered the zoning question that we are proposing to retain the existing A4 zone. And we are proposing to comply with the lot area and the lot frontage for this particular zone. Was that comment heard?
So,
Hello? Yeah.
so essentially you're saying that it's an A4 now, the splitting of into two lots would just remain A4, and that if allowable under the way it was as an A4, it should be okay under the two of them being split apart and remaining A4. Is that your
Yes.
basic argument?
Yes, from a zoning perspective, yes.
All right. And supplementary to Paul, can you comment on that?
Go ahead, Paul.
Through you, Mr. Chair. So while the lot dimensions might meet the A4 requirements, the bulk of our objection to this application is based on it inconsistency with the provincial policy statement, the official plan policies that are in place, which specifically discourage and in the provincial policy statements case outright do not permit lot creation in the ag areas except for surplus farm dwelling severances. Given the zoning of the properties in A4 and its proposed use as a mix of residential and agricultural use, it cannot be considered an agricultural lot split and still meet the provincial policy statements requirements as well as the OP's requirements. And it cannot also be a surplus farm dwelling severance because there is not an existing parcel that we are separating from a farm lot that's in active agricultural use. And of course, we can see that in the application and that the Appendix B, which is usually completed when or is required to be completed for surplus farm dwelling severances, was not completed for this application. No farm business registration numbers were provided because of course it was not identified as a surplus farm dwelling severance. So that appendix does not need to be completed, but as an agricultural lot split, it is staff's opinion that it does not meet the provincial policy statement or official plan policies. It's not so much a zoning issue, it's a PPS and OP issue. Thank you, Mr. Chair.
Thank you, Paul. Any other comments from members of the committee? Tom?
Not to be flippant, but just from a practical, I'm thinking just picturing through wagon loads of hay on the lot. You wouldn't even have room to turn around. So I think kind of it's a stretch to say it could be an agricultural operation.
Any other comments? Bill?
And I'll make add to Tom's comments. It's in my opinion, it's a as the planner has stated in her presentation, there's no agricultural being performed on the property now. So how can you split an A4 and split it into two and create two A4s? I just don't get it when there's non-existent agriculture on the property as it is today and what it has been in the past.
Any other comments? Yeah. Go ahead, Dave.
Motion to deny this application.
Do we have a seconder? Tom Marks? Call the vote, please.
Moved by Dave Jenkins, seconded by Tom Marks, resolved that severance application E7023 be denied. John Selden,
Agreed. Yes.
John Andrews,
Yes.
Tom Marks,
Yes.
Dale Unger,
Yes.
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 6-0, that motion is carried. So. It's still a notice of decision, so you can put that in.
The decision rendered today for this application will be circulated within 15 days. There's a 20-day appeal period from the giving of the notice of decision during which the applicant, the minister, a specified person, or any public body may appeal the decision or any condition imposed. If no appeal is received within 20 days of the giving of notice, the provisional consent becomes final. The applicant has 2 years to meet the conditions imposed and submit the necessary documents for certification, or the consent will lapse and a new application will be required. Please leave the identification signs in place until the appeal period ends, after which they can be removed. If you would like to be notified of today's decision, please request a copy by emailing landdivision@elgin.ca. A copy of the comment package is also available upon request and includes all correspondence received. Thank you. Next application is E71-23. Take notice that an application has been made by Isaac Wall, 5-3. That an application has been made by Isaac Wall, 5-3. Okay, I'll start over. Take notice that an application has been made by Isaac Wall, 53604 Harmony Acres Line, Aylmer, Ontario. The applicant proposes to sever a parcel with a frontage of 10.0585 meters, 33 feet, a depth of 40.593 meters, 134 feet, and an area of 408.30 meters squared, 0.1 acres, to sever one half of a semi-detached dwelling. The applicant is retaining a lot with an area of 408.30 meters, 0.1 acres, proposed to remain in residential use. Do any of the applicants or agents and or interested parties who wish to speak to this application, please introduce yourself to the committee. Who wish to speak to this application, please introduce yourself to the committee. I'll ask Paul to give any comments.
Thank you, Mr. Chair, through you to the committee. If I can please request that people watching on Zoom keep themselves muted until such time that they're ready to talk. Thank you. So this is a fairly straightforward application to split an existing semi-detached dwelling. It's just on the very edge of finishing construction, at least when I was there on my site visit a few weeks ago. So that's all they're doing essentially, is just putting the property lines down through the middle of the semi-detached to create two parts of the semi-detached, both of which can be individually sold. It is in a tier 3 settlement area. It is designated residential in the BAM official plan and is currently zoned village residential R1. So provincial policy statement wise 1.1.3.2 applies to this. Again, we're just severing through a semi-detached, because they're not in a plan of subdivision, they can't go through the part lot control process that we would usually normally use to split a semi-detached like this. In terms of the County of Elgin official plan, it is within a settlement area, which permits lot creation and a variety of densities of residential uses. And Municipality of Bayham staff have reviewed the application against their official plan and found no issues. In terms of the village residential zoning, the semi-detached dwelling meets the zone provisions that are currently in place. No rezonings or minor variances are anticipated. Staff are recommending that this application be approved with conditions. The conditions from the county are: number one, digital copy of the draft and final deposited reference plan be provided to the county. Number two, solicitor undertaking to provide a copy of the registered deed for the severed parcel once completed be provided to the county. And number three, municipal addressing be provided to Elgin County by the municipality to the satisfaction of the county. Bayham's conditions being requested are: number one, that the owner provides an engineered grading and stormwater management plan for each parcel to demonstrate that each will drain properly with no negative impacts on the neighboring lands or the street, all to the satisfaction of the municipality. Number two, cash in lieu of parkland fee payable to the municipality is required in municipal bylaw number 2020-053. Number three, planning report fee payable to the municipality. Number four, provide a digital copy of the plan of survey. And number five, that an electronic version of the reference plan be submitted to the satisfaction of the municipality. Thank you, Mr. Chair.
Thank you, Paul. Any comments from any of the members of the committee? Moved by John Andrews. Seconded by Bill Unger.
Moved by John Andrews, seconded by Bill Unger. Resolved that severance application E7123 be approved, subject to conditions. John Selden,
Yes.
John Andrews,
Yes.
Tom Marks,
Yes.
Bill Unger,
Yes.
Dave Jenkins,
Yes.
Ian Fleck,
Yes.
6-0, that motion is carried.
The decision rendered today for this application will be circulated within 15 days. There is a 20-day appeal period from the giving of notice of decision, during which the applicant, the minister, a specified person, or any public body may appeal the decision or any condition imposed. If no appeal is received within 20 days of the giving of notice, the provisional consent becomes final. The applicant has 2 years to meet the conditions imposed and submit the necessary documents for certification, or the consent will lapse and a new application will be required. Please leave the identification signs in place until the appeal period ends, after which they can be removed. If you would like to be notified of today's decision, please request, a copy by emailing landdivision@elgin.ca. A copy of the comment package is also available upon request and includes all correspondence received. Thank you. Next application is E72-23. And on this one, there is a letter given to us this morning, and Paul will be discussing that letter. Take notice, an application is made by Peter Donaldson of the Dutton District Lions Nonprofit Housing Incorporated, 29475 Pioneer Line, Dutton, Ontario, for consent pursuant to section 53 of the Planning Act 1990, as amended to sever lands mutually known as One Lions Road. The applicant proposed to sever a parcel with a frontage of 19.75 meters, 64.8 feet, a depth of 43.67 meters, 143 feet, and an area of 4,100 meters squared, 1 acre, for a future 33-unit retirement facility. The applicant is retaining a lot with an area of 8,534.02 meters squared, 2.1 acres, proposed to remain in use as a retirement facility. Do we have any applicants or agents or interested parties who wish to speak to this application? Please introduce yourself to the committee. Could you stand up to the mic, please? And press the button at the bottom.
Mark and Kim Jewell, we sent a written submission yesterday afternoon.
Thank you. We will deal with it later. As I said, with Paul, we'll be dealing with it. At that time, we'll call on you.
So sit back down.
Yes, please. Do any other applicants or agents interested parties? Brooke, are you there?
Peter Donalds. Yes. Yes, we're, the Dutton Lions Club has, helped. We have 55 units right now for seniors
Whoa,
affordable
excuse-
housing and our
Excuse
proposal
me?
is to build another 33 units into our community.
Hold on, please, Brooke. Who's there with you?
They're with you.
I have Peter Donaldson here with me.
Okay, thank you very much. We'll call on you.
Peter Donaldson here with me.
Okay, thank you very much. We'll call on you. And I'll call on Paul to give the report, please.
Thank you, Mr. Chair. So through you to the committee,
Please.
this application is for the creation of a new parcel to be used for a future 33 unit retirement facility. The applicant is retaining the existing facility, which is already used as a retirement facility and will continue its existing use. It is currently designated as a Tier 1 settlement area in the Elgin County official plan. It is designated residential in the municipality's official plan, and it is currently zoned Village Residential 2, Exception 1. And just to speak to that zone in particular, that zone currently permits a apartment dwelling for seniors already. So there is no issues in terms of the zoning for the proposed use of that land. With respect of the provincial policy statement, section 1.1.3.2 applies. It is a settlement area, and the provincial policy statement encourages a variety of land uses and densities which efficiently use land and resources, are appropriate for and efficiently use the infrastructure and public services facilities where they are available. With respect of the County of Elgin official plan, it is a Tier 1 settlement area. Those are the largest settlement areas in the county and are most adept to supporting this sort of mixed, not mixed, medium density residential use. Staff have reviewed the application against the general consent criteria of the official plan and have found no deficiencies. Engineering staff have also reviewed this application and do have a few conditions, which I will get into later. In terms of the municipality of Dutton Dunwich's official plan and zoning bylaw, the proposal conforms to the municipality's official plan. As I mentioned, the zone already permits apartment dwellings, senior citizens dwellings already. And the applicants have submitted as part of their application a draft site plan. They will have to go through site plan approval later after this is approved before they can start construction. But just in a preliminary analysis that was performed by Dunwich's planner, there are two deficiencies in terms of the zoning, and those are maximum building height and rear yard depth. They are proposed to deal with both of those through a minor zoning bylaw amendment. All other issues are in conformity with the zoning bylaw, including parking. Staff at the county and the municipality are recommending that this application be approved with conditions. The county conditions being requested are: number 1, digital copy of the draft and final deposited reference plan be provided to the county. Number 2, solicitor undertaking to provide a copy of the registered deed for the severed parcel once completed be provided to the county. Number 3, municipal addressing to be provided to Elgin County by the municipality to the satisfaction of the county. Number 4, that the owner acknowledges being advised that there shall be no direct access to Miller Road. The conditions from the municipality are: number 1, that a zoning bylaw amendment is in full force and effect for the severed and retained parcels. Number 2, that municipal drain reapportionments have been completed. Number 3, that mutual drainage agreement under section 2 or 4 of the Drainage Act has been provided to provide a legal drainage outlet for the newly created lot. Number 4, that 2 hard copies and 1 digital copy of the registered survey have been provided to the municipality. Number 5, that taxes are to be paid in full. Number 6, parkland fees as set out in the fees bylaw. Number 7, that all Dutton Dunwich planning application fees set out in the fees bylaw be paid to the municipality. Number 8, that 911 sign and or municipal address be established for the severed and retained parcels. Number 9, an entrance permit or clearance letter to be issued by the road authority. Number 10, that the solicitor provides an undertaking that a copy of the registered deed for the severed parcel, once the transaction has occurred, will be provided to the municipality. And then now to address the letter that was submitted last night, which all of you have been distributed a copy this morning. This was submitted by Mark and Kim Jewell. Like I said yesterday afternoon, it is a letter of objection to the application on numerous grounds, most of which will be addressed through site plan control. They're not issues that the land division committee necessarily deals with. It is mentioned in the letter that the County of Elgin denied Dutton Dunwich's request to rezone the property. We at the county don't handle zoning bylaw amendments. I'm unaware of what that is referring to. In terms of the water issues that are mentioned, as the municipality has identified in their conditions, drainage issues will have to be dealt with through the severance process, as well as through site plan control, with grading and on-site overland flow drainage being provided for stormwater. I think that's it. Thank you, Mr. Chair.
Thank you, Paul. Any comments from any of the members of the committee? You have a comment, Mrs. Jewell, or? No comments? Oh, thank you.
Just to note that these comments, some of them are valid, but that will be looked at the local level through site plan. So, you know, I have a comfort that don't go away thinking that they've been ignored. They will be addressed, but not at this table today. But
Any other comments from any members? Moved by John Andrews. Seconded by Tom Marks.
Moved by John Andrews, seconded by Tom Marks. Resolved that severance application E 7223 be approved with conditions. John Zeldin,
Yes.
John Andrews.
Yes.
Tom Marks,
yes,
Bill Unger,
Yes.
Dave Jenkins,
Yes.
Ian Fleck,
Yes.
6-0. That motion is carried.
Circulated within 15 days. There is a 20-day appeal period from the giving of notice of decision, during which the applicant, the minister, a specified person, or any public body may appeal the decision or any condition imposed. If no appeal is received within 20 days of the giving of notice, the provisional consent becomes final. The applicant has 2 years to meet the conditions imposed and submit the necessary documents for certification, or the consent will lapse and a new application will be required. Please leave the identification signs in place until the appeal period ends, after which they can be removed. If you would like to be notified of today's decision, please request a copy by emailing landdivision@elgin.ca. A copy of the comment package is also available upon request and includes all correspondence received. Thank you. E 73-23. Take notice that an application has been made by Dave Rowe, Tillsonburg, Ontario, as amended to sever lands municipally known as 50786 Charlotte Line. The applicant proposed to sever a parcel with a frontage of 58.1 meters, 190 feet, and a depth of 59.69 meters, 195 feet, and an area of 0.35 hectares, 0.86 acres, to sever a dwelling that is surplus to a farming operation. The applicant is retaining a lot with an area of 39.67 hectares, 98 acres, proposed to remain in an agricultural use. Any applicants or agents or interested parties who wish to speak to this application, please introduce yourself to the committee.
Yes, good morning, Dave Rowe. I'm the agent on behalf of the Reimer family, who are the owners of the property. Thank you.
Thank you, Dave. I'll now ask Paul Clark to give the reports from the municipality and the county.
Thank you, Mr. Chair. Through you to the committee, this application is to sever a dwelling that is surplus to a farming operation. It is designated agricultural area in the County of Elgin official plan. It is designated agricultural national gas reserve and mineral aggregate resource area in the local official plan, and it is currently zoned agricultural. With respect of the provincial policy statement, this is a fairly straightforward and standard surplus farm dwelling severance. The applicant proposes to sever a lot of less than 1 acre from the existing agricultural land, which the retained size of which is 98 acres. In terms of the County of Elgin official plan, this meets the official plan policies for surplus farm dwelling severances. Township of Malahide is proposed a condition to rezone the retained land to one that prohibits residential lot development, which will satisfy both the provincial policy statement and our official plan. Just to note that during a site visit, it was noted that there is an existing hydro pole that runs across the subject land. So we are proposing a condition from the county that a easement be established for that hydro pole. But other than that, we see no issues with that. And that's just a minor addition that will be added. The applicant or the agent and I did meet on the subject land actually by chance in doing that site visit and discussed it, and has no objections to that condition and us dealing with it through that way. Given that, township and county staff are recommending that this application be approved with conditions. The conditions being requested from the county are: number 1, digital copy of the draft and final deposit reference plan be provided to the county. Number 2, solicitor undertaking to provide a copy of the registered deed for the severed parcel once completed be provided to the county. Number 3, municipal addressing to be provided to Elgin County by the municipality to the satisfaction of the county. Number 4, that the applicants register an easement with a total width of 3 meters, 1.5 on either side of the existing hydro pole in the severed lands in favor of the owner of the retained lands. The necessary documents for the registration of the easement, including the details of the terms of the easement, be provided to the secretary treasurer at the same time as the deeds for stamping for the creation of the severed lot. And the conditions from the township of Malahide that we are requesting are: number 1, that the applicant initiate and assume, if required, all engineering costs associated with the preparation of a revised assessment schedule in accordance with the Drainage Act as amended, with a deposit to be paid in full to the township prior to the condition being deemed fulfilled. If the deposit does not cover the costs of the revised assessment schedule, the applicant will be billed for any additional costs incurred. Number 2, that all entrance permits are required from the appropriate road authority as per our entrance control policy. Number 3, any required road widening is to be complete, or the necessary agreements are in place with sufficient security posted to cover the costs of the works prior to the condition being deemed fulfilled. Number 4, that the applicant be required to retain the services of a professional designer and have an engineered lot grading development plan and ditch grading plan prepared in accordance with good engineering practices that are suitable to the township prior to the condition being deemed fulfilled. The applicant will be required to comply with bylaw 05-959 for the dumping of fill, removal of topsoil, and alteration of grades when a building permit or other site works are completed. The need for a certified grading plan and or municipal drain connection will be determined at that time. Number 5, that all outstanding work orders or bylaw enforcement issues be resolved to the satisfaction of the chief building official prior to the condition being deemed fulfilled. Number 6, that the applicants initiate and assume all required planning costs associated with the required zoning amendment is required in accordance with the Ontario Planning Act, with such costs to be paid in full to the township. and that the required process be successfully completed prior to the condition being deemed fulfilled. Number 7, confirmation that a private sewage system be confined entirely within the boundaries of the newly created parcel. That system be in conformance with all required setbacks from lot lines prior to the condition being deemed fulfilled. Number 8, that the necessary deeds, transfers, and charges for certificates and or instruments necessary for registration be submitted prior to certification, all of which are to be fully executed. Number 9, that all applicable property taxes, municipal fees, and charges be paid to the municipality prior to the stamping of the deeds. Number 10, the electronic version of the reference plan be submitted to the satisfaction of the municipality. Number 11, that the applicant is responsible to apply and pay fees to the township with respect to civic addressing number/signage for the severed and retained portions of property prior to the condition being deemed fulfilled. Thank you, Mr. Chair.
Thank you, Paul. Any comments from any of the committee members?
I move to accept.
Moved by Bill,
Seconded by Dave.
Moved by Bill Unger, seconded by Dave Jenkins, resolved that severance application E7323 be approved with conditions. John Selden,
Yes.
John Andrews,
Yes.
Tom Merks,
Yes.
Bill Unger,
Yes,
Dave Jenkins,
Yes.
Ian Fleck,
yes.
6-0, that motion is carried.
Thank you.
The decision rendered today for this application will be circulated within 15 days. There is a 20-day appeal period from the giving of notice of decision, during which the applicant, the minister, a specified person, or any public body may appeal the decision or any condition imposed. If no appeal is received within 20 days of the giving of notice, the provisional consent becomes final. The applicant has 2 years to meet the conditions imposed and submit the necessary documents for certification, or the consent will lapse and a new application will be required. Please leave the identification signs in place until the appeal period ends, after which they can be removed. If you would like to be notified of today's decision, please request a copy by emailing landdivision@elgin.ca. A copy of the comment package is also available upon request and includes all correspondence received. Thank you. Three, take notice that an application is made by Dan McKillop, 29094 Silver K Line, Dutton, for consent pursuant to section 53 of the Planning Act, as amended to sever lands municipally known as 23625 Pioneer Line. The applicant proposes to sever a parcel with a frontage of 48 meters, 157 feet, and a depth of 122 meters, 400 feet, and an area of 5,856 meters squared, 1.45 acres, to sever a dwelling that is surplus to a farming operation. The applicant is retaining a lot with an area of 75.8 hectares, 187 acres, proposed to remain in agricultural use. Do we have any applicants or agents or interested parties who wish to speak to this application? Please introduce yourself to the committee.
Dan McKillop.
Thank you. Dan McKillop. I'll now call on Paul to give us reports from the municipality and the county.
Thank you, Mr. Chair, through you to the committee. So this is another fairly straightforward application for a surplus farm dwelling. The applicant is proposing to sever off about 1.5 acres from the existing farm. The retained lands will be 187 acres. It's designated agricultural in both the county and municipal official plans and is currently zoned agricultural A2. The provincial policy statement, of course, is supportive of surplus farm dwelling severances. In terms of the official plan, the lot size is more than large enough to maintain the flexibility of agricultural uses for the retained land. And of course, surplus farm dwelling severances are permitted in our official plan. In terms of the West Elgin official plan and zoning bylaws, staff have reviewed this application and noted no deficiencies. They are again requesting a condition to rezone the retained farmland to one that does not permit residential development in accordance with the provincial policy statement and official plan policies. This application is consistent with the PPS, complies with the official plans and the zoning bylaw, And staff are recommending that this application be approved with conditions. The conditions from the county are being requested are: number one, digital copy of the draft and final deposited reference plan be provided to the county. Number two, solicitor undertaking to provide a copy of the registered deed for the severed parcel, once completed, be provided to the county. And number three, municipal addressing be provided to Elgin County from the local municipality prior to final approval to the satisfaction of the county. The conditions from the municipality of West Elgin that are being requested are: number one, that the applicants meet all the requirements, financial and otherwise, of the municipality to the satisfaction and clearance of the municipality. Number two, that the applicant provides a description of the lands to be severed, including any applicable easements and or rights of way which can be registered in the land registry office to the satisfaction and clearance of the municipality. Number three, the applicant solicitor provides an undertaking to the municipality to provide a copy of the registered deed for the severed parcel once the transaction has occurred to the municipality. Number four, that the severed and retained lands are transferred to the prospective purchaser, Michael D. Simon, as outlined in the purchase agreement. That the septic system assessment be completed for the severed parcel, dated August 24th, 2023, be reviewed and revised if necessary to the satisfaction and clearance of the municipality. Number six, that the applicant demonstrate that there is appropriate access to the retained farm parcel to the satisfaction of the municipality and or county. If a new access is required, an application shall be made to the applicable approval authority and a new access installed at the applicant's expense and to the satisfaction of the applicable road authority. Number seven, that the applicant successfully apply to the municipality for zoning bylaw amendment for the severed and retained parcels. Such amendment of the zoning bylaw must come into full force and effect pursuant to the Planning Act to the satisfaction and clearance of the municipality. Number eight, that the applicant have a drainage reapportionment completed if required pursuant to the Drainage Act to the satisfaction and clearance of the municipality. Number nine, that prior to the final approval of the county is advised in writing by the municipality how the above noted conditions have been satisfied. And number 10, that all conditions noted above shall be fulfilled within 2 years of the notice of decision. So the county of Elgin is authorized to issue the certificate of consent pursuant to section 53, subsection 42 of the Planning Act. Thank you, Mr. Chair.
Thank you, Paul. Any comments from any of the members of the committee? John?
Thank you, Mr. Chair, through you. Mr. McCullough, can you clarify? It appeared as if there was a metal clad barn on the proposed severed. And is it good for livestock? And also the application said there was no barn within 750 meters. Am I correct on that?
Yeah, there is a metal clad barn and it's used for manufacturing right now by the present owner. It cannot hold livestock, and therefore that's the reason why there is no livestock barns within 750 meters. And that can be confirmed by the building inspector of West Elgin.
Thank you.
Any other comments from anybody?
I'll move.
Moved by John Andrews. Seconded by Tom Marks.
Moved by John Andrews, seconded by Tom Marks, resolved that severance application E7423 be approved with conditions. John Zeldin,
Yes.
John Andrews,
Yes.
Tom Marks,
Yes.
Bill Unger,
Yes.
Dave Jenkins,
Yes.
Ian Fleck,
Yes.
6-0. That motion is carried.
The decision rendered today for this application will be circulated within 15 days. There is a 20-day appeal period from the giving of notice of decision during which the applicant, the minister, a specified person, or any public body may appeal the decision or any condition imposed. If no appeal is received within 20 days of the giving of notice, the provisional consent becomes final. The applicant has 2 years to meet the conditions imposed and submit the necessary documents. For certification of the consent will lapse and a new application required. Please leave the identification signs in place until the appeal period ends, after which they can be removed. If you'd like to be notified of today's decision, please request a copy by emailing landdivision@elgin.ca. A copy of the comment package is also available upon request and includes all correspondence received. Thank you.
Thank you very much. Merry Christmas to you all. So I likely won't see you again this year.
Thank you. Okay, the next meeting is November the 22nd. Are we off?
Just got to adjourn first.
Yeah. Are we ready for adjournment? Moved by Dave Jenkins, seconded by Bill Unger.
Moved by Dave Jenkins, seconded by Bill Unger, resolved that the committee adjourn at 10:08 a.m. on October 25th, 2023, to meet again at 9 a.m. on November 22nd, 2023. John Zeldin,
Yes.
John Andrews.
Yes.
Tom Marks,
Yes.
Bill Unger,
Yes.
Dave Jenkins,
Yes.
Ian Fleck,
Yes.
6-0, that motion is carried.